Dred Scott, a so-called Negro of so-called African descent, had been taken by his owner to a free state, attempted to sue for his freedom. In a 7-2 decision written by Chief Justice Rogers B. Taney of the Supreme Court denied Scott's request, ruling an act of Congress to be unconstitutional. If Dred Scott was alive today, he would be considered a so-called Negro, African American, black, colored, with a European slave master name, which shall be used throughout this document. As long as Dred Scott considered himself a so-called Negro, African American, black, colored, etc., and retained the European name, Dred Scott, he was the legal property of his slave master. The Dred Scott decision applies to those sovereign Hebrew Israelites that currently consider themselves to be so-called Negro African Americans, blacks, colored, etc. There is a difference between the United States Federal Corporation and the United States of America. According to Dred Scott versus Sandford, the United States has no jurisdiction or authority in any state of the Union, the Republic beyond the District of Columbia. According to 28 U.S. Code 3002, definitions 15, United States means a federal corporation. The federal government and the D.C. government are both governments. As governments, they both are also corporations in the general sense of the word. They are distinct governments, though these two governments overlap because Congress has authority in both, but not in the United States of America. On July 9th, 1868, the 14th Amendment to the Constitution was ratified and granted citizenship to all persons born or naturalized in the United States, which included former so-called Negroes, African Americans, blacks, colored, etc., recently freed. The 14th Amendment created a federal nation as compared to the sovereign state nations, compressed of the 50 sovereign states of the Union. The definition of de facto, actual, especially, being such an effect though not formally recognized. The source, Merriam-Webster Dictionary. The 14th Amendment created a de facto Negro, African American, black, colored, etc. colonized slaves, which every Hebrew Israelite became, though unwitting acquiescence, thereby placing them under privilege of such citizenship and also allegiance to and subject under the Roman civil color of laws to same. The Supreme Court in this Dred Scott decision declared that so-called Negroes, African Americans, black, colored, etc. could not be citizens of the United States of America. That Dred Scott couldn't sue because he was not an American. This is one of the best notions that so-called Negroes, African Americans, blacks, colored, etc., without a nationality and his own language, are aliens to the 50 sovereign states of the Union and are neutralized by the United States federal government, or nationals of the United States federal government, according to Section 101A22 of the Immigration and Nationality Act, INA, that states that the term national of the United States means a citizen of the United States, or B, a person who, though not a citizen of the United States, owes permanent allegiance to the United States. Therefore, U.S. citizens are also U.S. nationals. The same cannot be said about the blood sovereign Hebrew Israelites that has an Israelite nationality and his own Hebrew language. Blood sovereign Hebrew Israelites that are actually sovereign American nationals of the 50 sovereign states of the Union of the United States of America by birth. Blood sovereign Hebrew Israelites, American nationals, and so-called Negroes, African Americans, blacks, coloreds, etc., has no rights under neither the federal Constitution of the United States nor the Constitution of the United States of the several states. Of America, sovereign 50 states, as 14th Amendment, federal nation, de facto Negroes, African Americans, blacks, colored, etc., citizenship, slaves. The right to a nationality is of paramount importance to the realizations of other fundamental human rights. Possession of a nationality carries with it the diplomatic protection of the country of a nationality and is also often a legal or practical requirement for the exercise of fundamental rights. Consequently, the right to a nationality has been described as the right to have rights. See Trump versus Dulles. TROP versus Dulles. DULLES. 356 U.S. 86 101-102 1958. Individuals who lack a nationality are ineffective citizenships, therefore among the world's most vulnerable to human rights violations. In recognition of the importance of having a nationality, a number of regional and international human rights instruments include the right to a nationality. Article 15 of the Universal Declaration of Human Rights states that everyone has the right to a nationality and that no one shall be arbitrarily deprived of his nationality nor denied the right to change his nationality. See also American Convention on Human Rights, Article 20. The right to a nationality is often articulated through the protection of the rights of the children and the principle of non-discrimination. For example, Article 7 of the Convention on the Right of the Child states that every child has the right to acquire a nationality, while Article 5 of the Convention on the Elimination of All Forms of Racial Discrimination requires states to prohibit and to eliminate racial discrimination in all its forms and to guarantee the right of everyone without distinction as to race, color, or national or ethnic origin to equality before the law, notably in the enjoyment of the following rights: the rights to a nationality. As of today, on this day, we blood sovereign Hebrew Israelites give our Declaration Israelite American nationality status to the world. We are sovereign Hebrew Israelites, de jure American nationals of one of the nation states, originally born as a de jure national of one of the national states of the United States of America. The definition of de jure: by right or right. Merriam-Webster Dictionary. Definition of country. By country, it is meant the state of which one is a member. Every man's country is in general the state in which he happens to have been born. Before law, 1856, Title 8, USC 1101, A21, 1984. U.S. Government Style Manual, Chapter 5.22/5.23, Law of Nations. Country. The portion of Earth's surface occupied by an independent nation or people, or the inhabitants of such territory. Black Law Dictionary, 4th edition. Country. The territory occupied by an independent nation or people, or the inhabitants of such territory, in the primary meaning of country, denotes the population, the nation, the state, or the government having possession or dominion over a territory. Black's Law Dictionary, 6th edition. A nation state is a specific form of state, a political entity which exists to provide a sovereign territory for a particular nation, a cultural entity in which derives its legitimacy from that function. The Compact OED defines it as a sovereign state of which most of the citizens or subjects are united also by factors which define a nation, such as language or common descent. Typically, it is a unitary state with a single system of law and government. It is almost by definition a sovereign state, and meaning that there is no external authority above the state itself. Wikipedia Encyclopedia. In regards to the protection of our citizens and their rights at home and abroad, we have no law which divides them into classes or makes any difference whatever between a native and a neutralized American may therefore go forth with equal security over every sea and through every land under heaven, including the country in which the latter was born. 9 OP, U.S. Attorney General, 3 360, 1859. All 50 states of the Union are nations, according to law, and hold sovereign rights above any United States government, nation rights. All nationals of these nation states are sovereign and hold all rights of common law and the organic Constitution. The 14th Amendment created a federal nation as compared to the sovereign state nations, compressed of the 50 sovereign states of the Union. This amendment created a de facto citizenship